5 seconds to go. Start. These criminal appeals are by 7 accused convicted and sentenced to life by the High Court of Judicature at Allahabad for the murder of 5 persons. The deceased belonged to or were associated with the same family. Two of them were brothers, the third was their minor son, and the other two were their close family friends. Apart from these criminal appeals, there is also a special leave petition filed by the informant PW1, who is the sole surviving brother in the family, praying for enhancement of the sentence from life to death, and also a writ petition seeking transfer of accused number 5 to a jail outside Uttar Pradesh for serving out the sentence in lieu of his influence in the state. The judgment of the High Court was rendered in an appeal against acquittal of all the accused by the trial court. The High Court, by its judgment impugned herein, reversed the findings of the trial court and convicted all the accused for the offences under sections 148, 302, read with 149, 307, read with 149 of the Indian Penal Code 1860, and sentenced them to life imprisonment. The details of the conviction and sentences are as under. All these accused were sentenced to undergo life imprisonment for the offence under section 302, read with section 149 IPC, and to pay a fine of rupees 20,000 each, in default to undergo 6 months additional simple imprisonment. The accused were sentenced to undergo rigorous imprisonment for 3 years for the offence under section 148 IPC, and to pay a fine of rupees 5,000 each, and in default to undergo simple imprisonment of 6 months. All the accused were sentenced to undergo 10 years rigorous imprisonment for the offence under section 307, read with 149 IPC, and to pay a fine of rupees 10,000 each, in default to undergo 6 months simple imprisonment. The acquittal of Ashok Kumar Singh A5 under sections 379 and 404 IPC by the trial court was upheld. Further, the acquittal of accused Sahab Singh A8 for an offence under section 25 of the Arms Act 1959, and the acquittal of accused Ashok Singh A5 for an offence under section 30 of the Arms Act was also confirmed by the High Court without any variation. With these findings, the criminal appeal of the state and the criminal revision of the informant PW1 were substantially allowed. The prosecution case as it unfolds in the first information report is that there has been a long-standing factional dispute between two groups in Hamirpur, UP. The group represented by Ashok Chandel A5 and the group represented by Shukla family were inimically disposed against each other for a long time. The FIR is about the incident that has occurred at 9:10 p.m. on 26th January 1997 as two events occurring one after another in quick succession. The first incident is in front of the gun shop owned by accused number 6, referred to as Naseem's gun shop, and the second incident is near the residence of Parma Pandit, which is about 50 to 75 meters from Naseem's gun shop. The two incidents are as follows. On 26 January 1997, Rajiv Shukla PW1 along with his servant went to the market in the evening of 26 January 1997 at around 7:30 p.m. to buy some Manarth card recovered from the place of occurrence had expired way back on 12th January 1994, which is more than 3 years prior to the incident. The trial court also found that the said Manarth card was not sealed and stamped like other pieces of evidence. While the trial court did not dispute that the railway Manarth card belonged to Ashok Kumar, it doubted the recovery from the place of occurrence. In view of the above findings and conclusions, the trial court acquitted all the accused of all the charges. Challenging the judgment of the trial court, the state preferred a criminal appeal and the informant PW1 filed a criminal revision before the High Court. We have undertaken a detailed description of the reasons and conclusions adopted by the trial court only to see if the High Court, while reversing an order of acquittal, had sufficient and cogent reasons to interfere with the reasoning of the trial court. A strict scrutiny of the judgment of the High Court is necessary, as an order of acquittal can be interfered with only for substantial and compelling reasons. Following the same structure adopted by the trial court, we will consider and examine the reasons adopted by the High Court with respect to each and every finding of the trial court. Stop.